If you've been following AI advancements with excitement, you may want to taper your expectations, because there's a lawsuit that threatens to bring everything to a screeching halt. In early February, Getty Images filed a lawsuit against Stability.ai Incorporated, the company behind the Stable Diffusion model, for what they argue is the brazen infringement of Getty Images. They claim that Stability.ai has copied more than 12 million photographs from Getty Images' collection, along with the associated captions and metadata, without permission or compensation. There are a lot of calls to slow down AI progress, including one by notable computer technology specialists, including Elon Musk. In late March, Elon, along with over 100 experts, signed a letter calling for a pause in the development of tools more powerful than GPT-4. Remember, Elon once owned a stake in OpenAI before selling his shares to Microsoft in 2018. Since then, he has displayed what can only be termed as seller's remorse. After it became apparent how powerful ChatGPT was, Elon threatened to make his own Truth GPT, which would give responses that align more with his right-wing worldview. His call to pause further developments of systems more powerful than GPT-4 was interpreted by some as a selfish move to buy himself some catch-up time. Because, let's face it, only a single company, OpenAI, has anything more powerful than the GPT-4 in development. While his proposals are unlikely to be implemented, the lawsuit brought by Getty has a real chance to be the death blow to progress in artificial intelligence technology. Let's look at what they're arguing, whether their case has merit, and whether Stability.ai stands a chance. Number 1. It looks like a duck, it must be a duck. The main argument made by Getty is that without its images, Stability.ai as a company and their model, Stable Diffusion, would probably not exist. Basically, they are claiming that Stability.ai accessed at least 12 million images from Getty through its public-facing website and loaded them into a computer memory in order to train their model. They did the same for all the accompanying detailed metadata and captions, thus allowing the model to understand what it was looking at in plain text. This, they say, is expressly prohibited in their terms of use. They make the argument that since images on Getty are well captioned, unlike images on, say, social media, the AI gets accurate training, which is invaluable to the accuracy of the output. So accurate are the outputs that Stability.ai can, and has launched in a paid service that directly competes with Getty. They state in the filing, quote, if, for example, Stability.ai ingested an image of a beach that was labeled forest and used that text-image pairing to train the model will learn inaccurate information and be far less effective at generating desirable outputs. As a result of this training, Getty argues Stable Diffusion oftentimes generates images that are highly similar to Getty Images. So similar that in some cases the AI generations come complete with the Getty watermark. They've included this side-by-side image of two soccer players. No one will claim they're alike, but you can clearly see where Stable Diffusion got its inspiration. The distorted Getty Images watermark on the right is the AI simply not understanding what to leave out. Here are a few of the other cases that were highlighted. Number 2. Getty has licensed other AI platforms, so Stability should also pay up. Getty argues that in appropriate circumstances, with the safeguards for the right and interest of its photographers and contributors, it does license the use of its collection. In fact, they state that they have already licensed millions of suitable digital assets to certain companies for AI and machine learning related training. They make the point that rather than Stability.ai attempting to negotiate a license, they copy the images with impunity to launch a competing product called Dream Studio, which has been adopted by millions. This, they say, deprives Getty and its contributors of fair compensation. They further argue that the distorted Getty logo appearing in some of the low-quality AI generations further dilute the Getty brand. Number 3. Contributory infringement. While not expressly mentioned, contributory infringement is implied. This is a secondary form of copyright infringement, where the supplier of the technology can be held liable, even if they themselves have not infringed on the copyright or patent. You know, like that time Sony was sued by Universal for selling Betamax, which allowed users to record live broadcasts. Getty points out that Stability is offering Stable Diffusion software to third parties, who then go on to produce their own content without paying any licensing fee. Getty states in the filing, quote, "Those third parties benefit from Stability AI's infringement on Getty Images, and, in turn, Stability AI benefits from the widespread adoption of its model." There are a few more arguments, but those are the main ones. Now, let's look at how Stability might get itself out of this pickle. Number 1. It looks like a duck, but it's not your duck. The main argument that Stability AI is likely to make is that Getty completely misunderstands or misrepresents how AI images are actually generated by the diffusion models. For many of us, it's easy to say, it looks like a duck, it's therefore a duck. But how diffusion models work is rather complex and would need an entire video. It's a technical topic, and I suspect the jury will have a hard time following. There's a link in the description explaining the technical aspects if you're interested. The summary of it is this: diffusion models, like Stable Diffusion, learn from the work rather than copy from it. Let's take a dog for example. Stable Diffusion model gets the general idea of a dog's features, but not a particular dog's image. So, while you can copyright your photo of a dog, you can't copyright the fact that dogs have 4 legs and 2 ears. Number 2. Fair use. If you're a regular on YouTube, you might have heard this term thrown around a bit. Basically, it means the use of copyrighted material for limited and transformative purposes, without seeking permission from the copyright holder. It is allowed by law, but the definition is subject to interpretation. Millions of dollars in legal fees have been spent trying to define it over and over again. This ambiguity may end up being Stability AI's best defense. In fact, a major independent research found out that of 350,000 Stable Diffusion images that were analyzed, only 109 of them were found to be direct copies, translating to a mere 0.03%. That means that the vast majority of Stable Diffusion's generations can in fact be argued to be transformative. If the transformation involved a single image, there would surely be no case. Should the rules be different when it's 12 million individual images? Or should the law be consistent? Well, I guess we'll find out soon. Number 3. Past precedent. In late February, the US Copyright Office ruled that images generated by an AI cannot be copyrighted. In fact, the argument can be made that AI-generated art really has no owner. Related to this, another argument can be put forward, that an AI model is simply the tool. Should the photocopier manufacturer be sued because someone reproduced a copyrighted book? In the famous Sony Betamax case, the Supreme Court, by majority, found Sony not liable for what users were recording. They stated that, quote, "The sale of copyrighted equipment, like the sale of other articles of commerce, does not constitute contributory infringement if the product is widely used for legitimate, unobjectionable purposes." Number 4. Can you copyright a style? While this is not included in the Getty lawsuit, there is a separate class action filed by a group of artists against Stability AI, Midjourney, and DeviantArt. One of the claims is that the AI models are generating art in the style of particular artists. It's true, you can input a prompt on Midjourney for an artwork in the style of a famous artist, and oftentimes the results are strikingly good. The class action claims that as a result, the value of their work has been devalued. But can you really copyright a style? On this, there happens to be a consensus that you cannot. Any artist is free to make their own art in a style that is similar to yours. So, if this argument does come up, it could be the first to be thrown out. Number 5. Who owns the copyright? One of the questions a copyright infringement lawsuit tries to answer is whether the copyright holder actually owns the copyright to what is in dispute. Now, when you start talking about an AI-generated image, that question becomes an order of magnitude harder to answer. Say for instance this was not Getty in question, but rather an individual artist who doesn't happen to own 12 million images. A single final output by the AI very likely contains components and training data from thousands, if not hundreds of thousands of images. Yes, it could be true that the generated image closely resembles that of the artist, but the AI could not possibly train itself on a single image. In this case, who owns the copyright? The answer is, we simply don't know. Getty is in a position to authoritatively state that Stable Diffusion was trained on its massive catalog. But what about the individual artist? Because remember, Getty is just one of many of Stability AI's resources. They could have scraped the entire internet, including your Facebook and Instagram posts for all we know. Although Getty alludes to only 12 million images, we know for a fact that Stable Diffusion was trained on at least 2.3 billion images. This will be a very difficult decision for any judge or jury to answer. Number 6. Purpose of the AI-generated images. Let's say that your little sister loves Elsa from Frozen. So, you get your artist friend to draw the cartoon character. Then you proceed to make a print and hang it on her bedroom wall. Should you expect Disney lords to come knocking on your door? Of course not. But if you take that drawing, reproduce it, print it on t-shirts, then sell them on Etsy, boy oh boy are you in big trouble. So, if the court finds that in fact Getty's copyright was infringed, should the end purpose of the AI-generated image be considered? In such a situation, no one is doubting that Getty owns the rights to the source material. But just like Disney owns Elsa, shouldn't copyright enforcement only be applied to the person commercializing the final output? In other words, if you sell Elsa t-shirts, does Disney sue your artist friend or you the seller? Substitute the artist for Stable Diffusion. Number 7. What about humans? The main argument made by Getty is that Stability AI scraped its images, metadata, and captions on a massive scale to train Stable Diffusion. However, the question can be asked whether it should matter if it was a single image or 12 million of them, whether it should matter if it was done by a human or a computer. Every artist ever born trains themselves on other people's work. That's why you'll often find aspiring artists making sketches on their drawing books in museums. They get inspiration from their peers, and no one ever accuses them of copyright infringement. When you think about it, that's the same thing the AI model is doing, but on a massive scale. Should the rules be different for computers? Let's wait and see. Getty states that Stability AI has caused and will continue causing irreparable harm for which there is no adequate remedy at law. They believe they are entitled to damages sustained in the past, present, and future, as well as all additional profits obtained by Stability AI. They promise to provide a dollar figure during the trial, but already hint that it would be out of this world. They write, quote, Getty Images is entitled at its election as an alternative to an award of actual damages and any additional profits earned by Stability AI to recover statutory damages of up to $150,000 for each infringed work. Since we're talking about 12 million images, you can tell that this will be a blockbuster event. The company is demanding a trial by jury. There is no consensus on how this will play out. Both sides have some pretty great points. It's likely some of Getty's claims will be dismissed, but they do have a strong case in others. Remember, the outcome of this case could influence all types of AI. The GPT model, for instance, is trained on unfathomable amounts of copyrighted data. Whatever the outcome, this will be a case that will define the advancement of AI, not only in this decade, but perhaps for the rest of the century. And if America sues itself out of the AI race, we should remember that nothing will stop China, Russia, and the rest of the world from building their own massive AI models and systems. It's truly a moment of reckoning.